Hello viewers, how are you all today? Today we have a discussion on tort as a civil wrong and its comparison with other wrongs such as crime, contract and breach of trust. So the Latin word tortus, which means twisted, is where the word tort comes from. Therefore, it also covers behavior that is twisted and crooked rather than straight or legal. The term tort is roughly equivalent to the English word wrong. However, not all wrongs are torts. According to Salmon, a tort is a civil wrong for which the remedy is an action at common law for unliquidated damages and which is not exclusively the breach of a contract or breach of a trust or other mere equitable obligations. According to Fraser, a tort is an infringement of a private individual's right in rem, giving a right of compensation at the suit of injured party. The classic definition of tort is one given by Winfield. Tortious liability arises from a breach of duty primarily fixed by law. Such duty is towards persons generally and is breach in redressal by an action for unliquidated damages. This area of law mostly consists of torts or unlawful acts in which one is held accountable for their action when they infringe another person's legal rights in some other way and is required to provide the injured party with damages or compensation. A tortious act is one that is committed by a person who is known as a tortfeasor and also known as a wrongdoer. Take this as an example. Mr. A, the tortfeasor, discharges B in front of the public, harming B's reputation. Mr. A must pay Mr. B damages since he violated the law against defamation. The law has granted everyone the right to enjoy their own property, and if you interfere with someone else's property, you are responsible for that. Accordingly, if you enter someone else's property, you will be held liable for trespass. Contrary to contracts, no scientific description that might specify the precise components of a tort has yet been possible. For no other reason than that the wrongs covered by the tort law are diverse in nature and each has a unique origin story. Unliquidated damages or compensation that has not yet been decided, specified or agreed upon by the parties are frequently available to the injured party in a tort action and will be decided by the judge based on the facts and circumstances and injuries suffered by the party who approaches the court. The majority of tort law is founded on people's everyday interactions with one another and their common sense. Some examples of such civil wrongs or torts are nuisance, negligence, trespass, defamation. At a later time in this course, these ideas will be covered in greater detail. Therefore, today it is necessary for us to understand torts and talk about the crucial points that should be remembered when dealing with them. Now, moving on to the next aspect of our lecture, we'll talk about that how tort is a civil wrong, but it is also different from other civil wrongs. So, a tort is a type of a civil wrong that is distinct from other civil wrongs. Although, fundamentally, all torts are civil injuries, but not all civil injuries are torts. Consider, for instance, an individual's commission of a public nuisance is not a tort, but still the Attorney General must take legal action. For instance, the government is empowered to take quick action against someone who unlawfully blocks a public road, causing an annoyance that wouldn't otherwise occur. However, if a particular person is sufficiently inconvenienced by the obstruction, resulting in serious loss, either financial or physical, the aggrieved party may seek damages for the straightforward reason that he directly suffered as a result of the wrongdoing. Simply put, the second instance is a tort since the party who is directly harmed by the improper act is involved. Whereas the act in the first case was a civil wrong but didn't constitute a tort. However, in the first instance, the wrongdoing had an impact on society as a whole. Once more, let's revise this concept that failure to perform legal obligation is not a tort. The issue of a writ, maybe a mandamus, is a remedy for this situation. Despite being a civil wrong, it is not a tort. Torts include negligence, battery, assault, libel, and defamation. A breach of contract, while potentially bad, is not a tort. The idea is that if two companies are negotiating a contract, they should be able to anticipate future issues and define in the agreement what should happen in the event of something going wrong. If they fail to do so and anything goes wrong later on with only monetary losses, they are still obligated by the contract. According to Winfield, tortious duties are a result of the law itself and do not require the approval or agreement of the people who are exposed to them. I have a responsibility under the law not to hurt you or slander you. I am required to perform this responsibility because I am not because I have committed to do so with you. False representations, for instance, could be an exception, but in general, that is the rule. Failed expectations are strictly a contractual issue, which is a civil wrong, but does not fit into the tort category because one party expected to profit handsomely from a commercial arrangement but didn't. A tort, as opposed to a right in personam, is the violation of a right in rem. According to Pollock, a tort is the breach of the general obligation that every member of a civilized community owe to their neighbors to not hurt them unless there is a legal justification or excuse. Understanding when someone who commits a civil wrong will commit a tort requires making the distinction between situations where someone commits a civil wrong by breaching a judge-made duty owed to another person and situations where someone commits a civil wrong by breaching a statutory duty owed to another person. It is important to determine if a wrongdoing is civil or criminal before proceeding further. If it is determined that the wrong is civil in nature, we must determine whether it specifically falls under open category of civil wrongs such as violation of contract and breach of trust. We can classify something as tort if we discover that it is not solely one of the other civil wrongs. So after looking tort as a civil wrong, now let's see that what is tort vis-a-vis other wrongdoings related to crimes, law of contract and breach of trust. First of all, we'll discuss tort vis-a-vis law of crimes. So the law of tort and the law of crime are two separate areas of the law with unique functions and goals. Criminal law deals with the punishment of people who have committed crimes against society, whereas tort law deals with civil wrongs and compensating people who have been mistreated. A subset of civil law known as tort law is concerned with compensating people who have been harmed by the conduct of others. Torts are civil wrongs that cause damage to a person or their possessions. They might be deliberate or accidental, and they can involve a variety of actions like carelessness, battery, assault, slander, and trespassing. Tort law's two main goals are to give those who have been mistreated legal recourse and to stop others from repeating the same behavior. One of the main tenets of tort law is the notion that people are responsible for their actions and can be held liable for the harm they cause. To establish culpability, the plaintiff must show that the defendant breached a duty of care due to them and that this breach was the cause of their harm. For instance, in a case of medical malpractice, the plaintiff must prove that the defendant, who is a doctor, breached their duty of care by failing to provide treatment that agreed with the industry standards of care and that this breach caused the plaintiff's harm. The goal of tort law is to make up for the plaintiff's damages rather than penalize the offender. The plaintiff is typically given financial compensation to compensate for their medical costs, lost wages, and other losses brought on by the tort. Punitive damages, on the other hand, are sometimes also granted by the court and are meant to penalize the offender for especially heinous actions. And where comes the criminal law? Now, criminal law, on the other hand, focuses on punishing people who have violated social norms. Theft, assault, murder, and fraud are only a few examples of the kind of offenses that are regarded as harmful to the society as a whole and are classified as crimes. The criminal law exists to uphold social order, safeguard public safety, and discourage people from committing crimes. In a criminal case, the state is the plaintiff, while the defendant is accused of breaking the law. To prove guilt, the prosecution must prove beyond a reasonable doubt that the defendant committed the crime. If the defendant is found guilty, they may face a variety of penalties, including fines, jail time, and in certain cases, even the death penalty. Innocent until proven guilty is one of the fundamental tenets of criminal law. This indicates that the burden of proof rests with the prosecution to establish the defendant's guilt. The defendant is not required to establish their innocence. The right to an attorney, the right to a fair trial, and the right to remain silent are just a few of the procedural rights that criminal defendants also have access to. Even though criminal law and tort law are two different areas of law, there are rare instances where they overlap. For instance, the defendant may also face criminal charges in circumstances involving deliberate torts like assault or battery. The defendant in these situations may be subject to both civil and criminal sanctions. So, in conclusion, the law of tort and the criminal code are two discrete subsets of law with unique functions and goals. While criminal law is concerned with punishing people who have committed crime against the society, tort law is concerned with making up for people who have been wronged by the actions of others. These two branches of law are separate and distinct fields of law that serve various purposes within the legal system, notwithstanding some instances where they interact. Let's see in our next topic, tort vis-à-vis the law of contract. Now, contract law and tort law are also two different separate areas of civil law with different guiding ideas, objectives, and standards. While both are concerned with settling conflicts between parties, there are substantial differences between the types of disputes and the remedies available under each department of law. Whether or not there is a contractual relationship between the parties, tort law deals with civil wrongs that cause pain or injury to a person or property. Torts can be deliberate, like assault, battery, or defamation, or they can be the result of negligence, such as when a doctor fails to give the patient the right medical care, or when a driver causes an accident because they are driving carelessly, Tort law's two main goals, as we have already discussed, are to compensate the harmed party and discourage others from repeating the same behavior. Contrarily, contracts between the parties that establish legal binding obligation are governed by the contract law. When two or more parties decide to exchange something of value, such as commodities, services, or money, a contract is created. Contract law exists to ensure that parties may rely on the promises made in a contract and to offer a process for resolving disagreements that develop when one party breaches a contract. The nature of the relationship between the parties is one of the primary distinctions between tort law and contract law. In tort law, it is not necessary for the parties to have a prior relationship, and the plaintiff is not required to establish that the defendant violated an obligation owed to them. The plaintiff must instead show that the defendant's act hurt them. In contrast, the parties have a legal obligation to uphold the term of the contract because they have established a specific relationship under an agreement. The remedies open to the harmed party are another distinction between the two branches of the law. According to tort law, the victim of an injury is entitled to restitution of their losses, including both economic, such as medical bills and lost wages, and non-economic, such as pain and suffering damages. Punitive damages may also be granted in some circumstances to punish the defendant for specially heinous actions. According to the terms of the contract and the type of breach, the injured party is often entitled to specific performance or monetary damages under the contract law. In addition, in contract law, the obligations and rights of the parties are governed by the terms of the contract. When one party doesn't carry out their end of the bargain, there is a breach of the contract. Contrarily, tort law is based on the duty of care due to others rather than the terms of an agreement. In general, the standard of care needed under tort law is one of reasonableness, meaning that the defendant must take the same number of precautions as a reasonable person would in the same situation have taken. In conclusion, even though both contract law and tort law are areas of civil law that deal with settling disagreements between parties, they differ in their nature, guiding principles, and available legal options. While contract law is responsible for regulating agreements between parties that generate legally binding duties, tort law concentrates on civil wrongs that cause harm or injury to a person or property. Now, after these two legs of law of crime and law of tort, let's see what is tort vis-à-vis breach of trust. We have already read that tort law deals with civil wrongs that harm or injure a person or piece of property. Intentional or unintentional wrongdoing that causes harm or injury is referred to as a tort. Now, in tort law, the plaintiff must establish both that the defendant owed the plaintiff a duty of care and the defendant's act resulted in the damage or injury. Tort law's two main goals, I think I have reiterated this point twice already in this lecture. So this is a very, very important point, that what are the two major goals of tort law. So tort law's two major goals are to make up for the plaintiff's losses and to stop others from acting in a similar way in the future. Contrarily, the term breach of trust relates to a breach of a fiduciary duty. The legal obligation to behave in the best interest of another person or entity is known as a fiduciary duty. A fiduciary obligation to behave in the best interest of the person or entity to whom it is owed results in the breach of trust. This can occur when a trustee mismanages assets, a lawyer violates a client's right to confidentiality, or a company officer pursues personal gains. So a breach of trust suit has different legal prerequisites than a tort claim. The plaintiff must establish all three elements of a breach of trust claim: that the defendant owed the plaintiff a fiduciary responsibility, that the defendant violated that duty, and that the plaintiff was injured as a result of that violation. It is the goal of a breach of trust claim to hold fiduciaries accountable for their actions, to ensure that they act in the best interest of the person or entity to whom they have a duty, and to make up for whatever pain the victim has undergone. One crucial difference between tort law and breach of trust law is the nature of parties' relationship. In tort law, as we have already discussed above as well, the defendant's action or inactions that cause the plaintiff's harm are usually used to demonstrate the connection between the parties. The relationship between the plaintiff and defendant is one of the fiduciary responsibility owed by the defendant to the plaintiff, and this is a breach of trust law. These relationships may include those between a trustee and beneficiary, a lawyer and a client, or a corporate official and shareholders. The type of remedy that may be used in another distinction between tort law and breach of trust law. The remedy in tort law is often monetary damages, which are meant to make up for the plaintiff's losses. The remedies of a trust law violation may differ depending on the particular facts of the case. For instance, a judge might require the trustee to return assets that were improperly managed to the trust, or a lawyer who violated their duty of confidentiality might be expelled from the bar. So in today's lecture, we have seen the three aspects of torts vis-à-vis the three other laws, that are crimes, contracts, and breach of trust. To sum up, while both tort law and breach of trust law are branches of legal system that deal with wrongdoings, they are distinct legal disciplines with distinct needs and objectives. Tort law deals with the civil wrongs that cause harm or injury to a person or piece of property, whereas breach of trust deals with the transgression of fiduciary obligations. To safeguard their interests and hold wrongdoers accountable, people and businesses must understand how these two legal disciplines vary. These are the major aspects of law of torts vis-à-vis other wrongs. With this, we come to the end of our today's lecture. Thank you for your patient listening. Thank you.